Okay, good morning to everybody. Today, the College of Commissioners has found and sanctioned infringements of antitrust rules by several pharmaceutical companies. These companies entered into anti-competitive agreements to delay the entry of generic medicines on the market. We have imposed fines totaling 145 million euros, including 93 million to be paid by the Danish company Lundbeck. You have all the details of this in the press release that Antoine will distribute to all of you. Let me briefly explain the facts. Citalopram is a medicine developed by Lundbeck to treat the symptoms of major depression. In 2002, this product, which was Lundbeck's best-selling medicine, was nearing the end of its life cycle. The patent protection for the molecule had lapsed, and the remaining patent protection was limited to certain manufacturing processes. At that point, it therefore became possible for competitors, namely Alpharma, Merck, Arrow, and Ranbaxy, to enter the market with generic versions of citalopram. One of them even started to sell generic citalopram, while others were all preparing to launch their own versions of the product. However, these generic competitors were close to entering the market. When these generic competitors were close to entering the market, Lundbeck, the so-called originator of the medicine, agreed with each of them that they would stay out of the market against a payment. Lundbeck did not prevent market entry by successfully enforcing its patent rights. Rather, it simply paid other companies so that they would not compete, giving them the equivalent of what they would have earned if they had entered the market. This means both the originator, Lundbeck, and the generic companies that agreed with Lundbeck shared the monopoly rents among themselves. One internal document even speaks of this group of companies as a club and refers, quote unquote, a pile of dollars being shared among participants. As you can imagine, all this occurred at the expense of patients who were deprived of access to cheaper medicines. It also harmed our public health systems, who for a longer period had to artificially bear the cost of an expensive medicine and one of the most widely prescribed antidepressants. We are not talking about a small difference in price here. In the UK, once generic versions of citalopram did enter the market, prices dropped on average by 90%. The practices we are sanctioning are simply unacceptable. By today's decision, we are confirming that the so-called pay-for-delay deals constitute severe infringements of EU competition law. They may cause severe harm to patients and taxpayers and must be sanctioned accordingly. The sanctions we have set are proportionate to the characteristics of the infringement we found. We applied our guidelines on the setting of fines. The level of the fines takes into account, in particular, the gravity and the duration of the breach of competition rules. And these fines aim both to sanction the infringers and to deter companies from engaging into such anti-competitive practices. By the way, yesterday we confirmed that we are in good company in this approach because in a long-awaited ruling, the US Supreme Court has just concluded that these pay-for-delay deals should be open to antitrust scrutiny. As the judge noted in this opinion, under such agreements, the patentee and the challenger gain, but the consumer losses. And in other sectors, the European Court of Justice has clearly confirmed in some of the rulings that paying competitors to keep them out of the market is a serious restriction of competition. The pharmaceutical sector is essential to our lives. Innovation can bring new or more effective cures and needs to be protected. But once the patent over the molecule has lapsed, price competition between the pharmaceutical companies that invented the original medicines and the generic makers plays a crucial role. Thanks to this competition, patients can have access to affordable healthcare. Through generics, they can get the same treatment significantly cheaper. It also ensures that public health systems can remain economically sustainable in these times of difficult budgetary constraints. Pharmaceutical expenditure absorbs significant portions of budgets and households, budgets of states and households. It is therefore crucial that European citizens are not deprived of cheaper health bills by anti-competitive practices. Moreover, competition by generics is also a dynamic force which stimulates pharmaceutical companies to continue to invest in research and to develop innovative treatments, as they cannot rely forever on their blockbuster products. For all these reasons, the practice of entering into anti-competitive agreements to delay the entry of generic medicines should come to an end once and for all. Since the inquiry that the Commission carried out into the pharma sector 4 years ago, in 2009, we have been monitoring patent settlements between pharmaceutical companies. These settlements have grown a lot over the last few years. I have to say that according to our analysis, the overwhelming majority of such agreements are entirely legitimate, as they do not involve any payments by originators to exclude generic companies. By avoiding the cost of expensive litigation, they may bring real benefits through these settlements. And we are analyzing those settlements only to pursue a harmful and a small portion of them. We are currently investigating a few cases, apart this Lundbeck case, and we will continue to fight against patent settlements that will try to exclude competitors from the market once the patent protection is no more there. Paying competitors to stay out of the market at the expense of European citizens has nothing to do with the legitimate protection of intellectual property. This is the first case we have adopted in this pharma sector regarding this pay-for-delay settlements, but I can promise you that this is not the last one. Thank you.
Thank you very much, Vice President. Are there any questions? I see there is one here.
Peter O'Donnell, European Voice. Commissioner, can you just clarify for me, the agreement itself was not illegal per se, is that correct?
To pay a company to avoid that they enter to the market is anti-competitive, for sure.
An agreement in itself is not per se illegal, so it's actually an agreement where there is payment that automatically becomes illegal. Is that the case?
It's payment to exclude the entry into the market of a competitor.
Okay, so we have a definite, if there's payment, it's illegal. If the payment is to exclude entry of a product. Okay. Can you also explain perhaps the legal basis behind this a little more? The interplay between competition law and intellectual property rights here is an interesting one. Could you expand a little on how you see the two things interfacing?
In this particular case, the patent of the medicine, of the molecule of citalopram had expired when Lundbeck paid the generic competitors to get the non-entry into the market. And in some other cases, you can have some payments that can also be anti-competitive, but this requires a case-by-case approach. But of course, if you are no more the protection of a patent because the patent has expired and you pay a competitor not to enter into the market, this is a very, very clear anti-competitive practice.
I see that there was another question here.
Olaf Christensen, Danish TV2. Can you tell us, have you any estimate how much money Lundbeck has made on this agreement? And furthermore, have you any indication whether or not patients have been deprived of this medication due to this agreement?
Well, during the investigation, we received information on how much Lundbeck paid to the generic companies. We know what were the figures of the Lundbeck sales of this drug, and the fines are calculated taking into account the turnover of the company in the last year, and we have information, as I said in my presentation, and you can maybe find more information regarding this, that once the pay for delay was no more valid, and the generics enter into the market selling this molecule, the prices went down 90% in the UK, in the example I gave to you.
Any other questions?
They've been deprived of this drug?
The patients have benefited from these lower prices, of course, once the patent protection has expired, and all the victims of this infringement can ask for compensation for damages.
Another question here?
Yes, Minaskau of the Danish news agency. Just a second. Do you have any examples of similar cases within the pharmaceutical industry? And another issue, or the same issue, Lundbeck has already said that they're going to appeal this decision. Could you tell us what's the process from here on?
Well, the lawyers of Lundbeck can explain to you what they will do. I don't know. They have all the right, of course, to appeal if they wish. Regarding the other question you mentioned before, the other cases, we are right now investigating formally 3 more cases of similar practices. Every case has its own characteristics, but we have 3 other similar cases under a formal investigation, and maybe in the future, as we are monitoring continuously these kind of settlements, if we will find again this kind of anti-competitive conducts, we will open more investigation. But I have to say that since we carried out this sector inquiry in 2009 and we started our monitoring of these kind of agreements, I have the impression that the anti-competitive practices has been reduced.
Matthew?
Good morning, Commissioner. I was wondering if you could help me understand this a little bit. You just said that when a patent is expired and a company pays a competitor to stay off the market, that's clearly anti-competitive. But in this case, the patent is actually still valid. So I don't quite understand how you say it's expired when actually it is still valid. It was approved by the European Patent Office. And then a procedural question. You say in the press release that this conduct dates back quite some time. This is from 2002, and we are in year 2013. Just wondering how that works. How do you fine a company for conduct that's more than 10 years old? And just finally, if you will, you made a reference to the U.S. Supreme Court decision. Obviously, the companies are disappointed with the decision yesterday, and they'll be disappointed with this one today. Do you think that generics will look at this decision and look at what happened for settlement agreements and say, well, perhaps the EU is not a good place to do business, and they might want to go to the United States or some other market?
To sell medicines in Europe, they have to be present in the European market, I can imagine, unless all the Europeans in need of some medicine or drug will buy it by internet. But I don't think it would be possible. So I think the European market will continue to be an extremely good market for companies unless they decide to act in an anti-competitive way. In this case, they will know today, better than yesterday, that the EU is against these pay-for-delay agreements. And this is clear for this case, for the cases we are investigating now, and for the possible future cases. The patent. The original patent for citalopram as a molecule expired. Lundbeck has, if I am not wrong, another patent on a process to transform the molecule into a product through the process called crystallization. But you can offer this molecule not only through crystallization, but through other means that were no more protected because the patent on the molecule had expired. So it's true that one process had still a valid patent, but not other means to produce the same molecule and to sell the same molecule to the patients. 2002, yes, it's true that this happened more than 10 years ago, but the legal possibilities to adopt the decision we adopted today have not prescribed. Have not prescribed. So we have all the legal possibilities to adopt the decision today, even if the facts took place more than 10 years ago. So we are not acting beyond the legal possibilities to adopt decisions every time that an anti-competitive conduct is confirmed through our investigations. The US Supreme Court had published 2 days ago this ruling. I think is a very important one. This goes with some differences in the details, but goes exactly in the same direction than our decision today. And I am very happy to learn that the US Supreme Court had confirmed this line that was the line of the Federal Trade Commission, but were legal doubts at the US level or in the US jurisdiction if the court at the Supreme level, the Supreme Court, will confirm or not what the FTC was trying to pursue in their investigation. Now the Supreme Court in the US has confirmed the same line with some particular details that are not exactly identical, but has confirmed the line is the base of our decision today, and hopefully the line that in the future the European Court of Justice will decide in the rulings.
Another question here.
Yes, Minna Skau of the Danish News Agency again on another case, SAS. Could you clarify what the investigation you're opening on SAS is about?
May I ask before if we have more questions on this case, and after I come back to you?
I think there were several. Nicholas here, and then we'll come back. No.
Yeah.
Oh, okay, yeah, go ahead. Yeah.
Who is first?
So have I a competitor there? Can I go? Right. Just on this question then of the relation to the Supreme Court ruling and so on, and how it differs from your approach. What I'd like to be clear about is whether you feel there's a need, or whether you're ruling that there's a need to investigate the precise nature of each of these pay-for-delay agreements, or whether your view is that these are per se illicit or in breach of competition law. As I understand it, the Supreme Court ruling says that it's necessary to assess these things in the full context of the market. Are you also looking at it in that way, or are you saying these decisions we make and we can make it as a sort of precedent that establishes an automatic illicit nature for such agreements?
Okay. All our decisions are based on a particular investigation of the particular case.
But forgive me, but you're setting something of a precedent here by saying that this one is something which, as Matthew was saying, there is still a patent valid on the process. I know that Lundbeck contests your claim that the patent is invalid, and they were litigating, I think, against a number of these things. You would say that you completely dismiss Lundbeck's claim that their patent was still valid, presumably, and therefore you are saying that there is no need for any further investigation. This is absolutely clear. They were doing a payment for settlement, a pay for delay, and that's illegal.
When the patent has expired and there is a payment to avoid the entry of a competitor, this is quite clear. But in any case, we will need, in every case, to open an investigation, to follow the steps of our antitrust investigation and to adopt a decision, as it is the case today with Lundbeck and will be the case in the future with other similar or analog investigations that we are developing right now. Can be other cases that are more complex, that are not exactly the same as to consider the payment of a company to their competitors once the patent has expired. Can be other cases with a different kind of situations, and we need to further investigate what are the limits of the patent protection in some cases, to what extent beyond the reasonable limits of a patent protection there can be also anti-competitive practices in these kind of settlements. Every time that there is a payment to a competitor, we have more doubts than if a patent settlement between two companies is not including any kind of payment. But I cannot anticipate to you how I will decide or how the Commission will decide the future cases. We will need to go case by case, and I come back here before the end of the mandate of this Commission with some other cases to explain in this particular situation how we consider the anti-competitive conduct. I will not discuss with you or through you with the Lundbeck lawyers. They will have to go to the court.
Nicholas?
Nicholas Hurst from Par Global. This case the latter proceedings were done remarkably quickly. I think that the statement of objections was sent 11 months ago and the oral hearing took place just 3 months ago. I was wondering whether it was such an obvious case that you were able to decide it in an unheard of short period of time, and whether you're able to ensure that the rights of defence of the parties were properly defended and not breached in order to rush out a decision. Thank you.
Of course, I can assure you that we have respected all the rights of the parties. We have followed all the steps in our procedures, and if we can accelerate our decisions following and respecting all the guarantees and all the due process elements in our procedures, I will be very happy. I don't like at all to spend years and years investigating one case if we can adopt decisions based on the procedural steps that we have to respect having been fulfilled. The reason why we can adopt this decision before than in other investigations in the past is the reason very simple. The reason is very simple. These guys that are there, the responsibles in DG competition of this case, has worked a lot, and has worked very well, by the way. I want to congratulate them, thanks to your question.
Maybe a quick follow-up.
And so does this set a precedent for future cartel cases? We should expect them to be resolved within a year or so of the statement of objections?
If we can work and advance in our investigations with lower deadlines, respecting all the rights of the parties, respecting all the steps in the procedure, of course, I would be very happy. Not always is possible, because in some occasions, not because of us, but because of the way the parties use their rights, the procedures are longer and the deadlines have to be respected, but in some cases there are no legal deadlines and they can make use of the rights to prolong our investigation before we are able to adopt a decision. But I can assure you that this decision has been based on all kinds of guarantees and procedural steps and due process requirements, because I stick very much, on the one hand, not to postpone in an unfounded way our decisions, but at the same time in respecting all kinds of guarantees on our procedures. And we have improved, by the way, the guarantees of the parties during these last 3 years.
One quick question, because we will need to leave the room for the midday press briefing soon.
Quick question, but maybe requires a long answer. In the U.S. Supreme Court ruling or opinion, they spoke a lot, the judges spoke a lot about how to determine the illegality of a settlement. And they specifically looked at the size of the payment as an indication that there may be something amiss. And in fact, they even used this word, is it possibly a surrogate, to show that there was a problem. The EU investigation, we don't have the exact numbers here, but they are in the millions of euros. I'm just wondering if your services looked at the actual size of the payments, or did it matter? Could it be a small amount, or did it have to be, let's say, enough to make a real difference for the generic company to stay off the market? It's the money that they would have made if they had been on the market.
For sure, we have looked at these payments, taking into account all the conditions and all the characteristics of these payments, and we know, after our investigation, exactly how much was paid to every company, and what was the reason why, and the consequences after the payments that took place. Okay, we had this question on...
Yes, we had one question on another subject, on SAS, I believe.
Yes, it was just basically to get you to describe what the investigation you're opening against SAS is about.
We are distributing a press release. We have decided today to open an investigation for possible non-compatible state aid in one of the instruments that has been used to support SAS. We consider that some of the instruments to support SAS are not considered as incompatible with our state aid framework, but in one particular case, in particular the revolving fund that was created, if I am not wrong, in 2012, we consider that we have serious doubts and we are obliged to open an investigation. This has been the decision today.